one of the most common employment law mistakes that these startups in California make, and not only startups but also many other companies that have been around for a while, is assuming that just because you call your worker a contractor, just because you put that label on them, and just because you have that worker sign an independent contractor agreement, this necessarily means that that worker is properly and correctly classified as a contractor under California law. In reality, however, what you call that worker and the type of agreement that that worker signs is of little or of no relevance at all to the proper classification of that worker as a contractor versus an employee. What determines his status is the degree of control that you, the employer, exercise over the manner that he performs his job duties. It depends on where that worker is working out from, who controls how he performs his job, who controls his hours, who provides him with equipment, with uniform, and many other factors. Now, why is this important? This is important because if you misclassify your worker as a contractor when in fact the circumstances of his work, the circumstances of his relationship with you are those of an employee, this can expose you to potential liability for a number of reasons. First, and probably one of the most significant liabilities that you could face, is for unpaid overtime. If that contractor works more than 8 hours a day or more than 40 hours a week, you may be liable for unpaid overtime. Also, if you classified that worker as a contractor, then this means that you're not paying his payroll taxes, and you're also not paying for his unemployment insurance contributions, and you also do not have workers' comp coverage for that worker. So if you fire that contractor, he will go to EDD, to the Employment Development Department. He's gonna claim unemployment benefits. You're not gonna have coverage for him. This is going to trigger an audit by EDD of your office. You're gonna be hit with penalties, and you're gonna have to pay extra so that that contractor who was improperly classified as a contractor, so that he can get unemployment benefits. And one of the worst and one of the most expensive from employer's perspective things that can happen to a contractor who is actually an employee is being injured on the job, suffering a severe injury. Imagine a situation where your contractor is injured. It turns out that he should be classified as an employee. You don't have workers' comp coverage for him, and then you have to pay for his injury, for his medical treatment, and a bunch of penalties. So these are three of the most significant and the most common types of issues and liabilities that can arise as a result of improper classification. There could be other issues with improper payroll taxes that, where you don't contribute to the payroll deductions of a worker who should be an employee, and then IRS, Franchise Tax Board, Social Security, Medicare, one or all of these agencies can audit you and can ask you to pay for the whole time that you incorrectly classified your worker as a contractor. So it's really, really worth making sure that you correctly classify your workers, whether they're contractors or employees. And a good, experienced employment lawyer can and should be looking at each situation in which you would like to classify your worker as a contractor, to make sure that you do it right and you don't set yourself up for significant liability and penalties and interest and fines and so forth. Thank you.